Hello and welcome to my presentation of tort law. Tort law is a civil wrong against another person. Tort claims usually involve state law and are based on the idea that individuals are liable for consequences of their conduct. In its essence, it's essentially people taking responsibility for something that has gone wrong or finding the responsible party. Now, there are two different types of tort law, intentional and unintentional. Unintentional essentially is negligence, so not being there or not having supervision. And intentional would be false arrest, invasion of privacy, assault, battery, libel, slander, or defamation. In this slide or in this presentation, we're going to go over 5 different cases of tort law within education and their outcomes. The first one we're going to go over is Hoyam versus Manhattan Beach City School District. In this case, a student, a 10-year-old boy named Michael, went to summer school and he went to the majority of his classes. And at the end of the day, he decided to leave early. When he was off of the school campus, he was actually injured and hurt by a motorcyclist. Now, we are going to figure out whether or not the school is responsible or if Michael is responsible. So, Michael and his mother alleged that the accident and the injuries were because the school were negligent in their supervision of Michael. They wanted to sue based on the injuries that Michael had and the emotional well-being that his mother came into because of her seeing her son in the hospital was extremely hard for her. Now, a school district bears duty to supervise students while on the school premises. So this happened in California, and in California, schools are only required to watch and have supervision for students on their campus. So the minute that Michael left the campus, it was no longer going to be up to the school to watch him, whether it was an admin or a teacher. Now, in my district, this would have been handled the same way. We are responsible for anyone who is on our campus and what will happen to them. But once you are off our campus, especially if you take yourself off campus, then it is all on you and it's your responsibility. The next case we're going to discuss is Daly versus Los Angeles Unified School District. In this case, a student named Michael actually passed away on his school campus. So Michael and his friends were at lunch and they were in a closed off area that was actually designed for students to have lunch in. On their way back to class, they began slap boxing, which is essentially boxing but with an open hand. So it's supposed to be less harmful. After a while, students started to gather around. About 30 students ended up watching these kids slap boxing, and everyone said that you could tell they weren't mad at one another, but that they truly were having a good time. In the end, Michael got slapped and he actually fell backwards and he hit his head, and he did end up succumbing to his injuries. So the case was tried by a jury, and the school was found guilty of negligence. During the trial, it came out that their plan of supervision was whoever was working in the gym that day was supposed to be watching that lunch area because it was close to the gym. The principal that day saw the gym teacher in his office and thought to himself, oh, cool, they're going to be supervised. These are not exact quotes. Now, when he went to his office, he actually ended up playing a card game during his lunch hour. And this is when Michael was struck and he died. So it was found that the school district was guilty. So if you'll see here, we actually had to go to court twice. So in the trial court, there was no negligence found on the district. But when it was appealed and sent to the Supreme Court found that the school was negligent and that the negligence was the proximate cause of death, due to the fact that if there would have been an adult there to tell the boys to stop horsing around or stop slapboxing, or even to ensure that there wouldn't become an audience so they wouldn't feel like they had to perform or anything like that, then Michael would have ended up living. The next case is Woodsmall, Mount versus Mount Diablo Unified School. This case was of a 9-year-old boy named Ronald, who was injured on the blacktop. So in school, the teacher decided that he needed to let these kids go to recess, or it was that time of the day. He had the students lined up in 2 rows, one with girls and one with the boys. And he said, okay, like, go ahead and go to the blacktop. You need to walk while you're in the school, but once you get to the blacktop, you can run. So he turns around and he locks his door, and then he walks towards his class lines. And by the time he had locked his door, he could only see the last 2/3 of his class line. So once they get to the blacktop, Ronald starts to, jet off, and he's pushed into a pole, and he injures his teeth. So he injured his front 2 teeth, which this photo is not of Ronald. This is just a different boy. And then they decided to take it to court to sue based on the personal injuries sustained by Ronald. Now, a jury was waived, so they didn't believe that people needed to sit in on this case, but Ronald did end up winning the case, and him and his father were awarded $5,270 and $195 for his medical bills and the court costs. If this were to happen in my district, I feel it would be a very similar circumstance. We are very strict on our supervision, and if something like this were to happen and go to court, we do have a union in my district, so if that teacher was signed up for their union, then they could be represented based on their monthly fees, so they wouldn't need to pay that. But I do believe that this would be the exact same way in Colorado Springs. Okay, next is Padilla versus School District Number 1. This actually is from 2001 in the Denver Public Schools. So Shane Padilla was a 10-year-old developmentally disabled child, and due to her medical condition, she had to be in the hospital a lot, whether that was surgeries or blood drawing or anything like that. And due to her presence in the hospital, she did associate physical restraint with pain, and it would agitate her or frighten her or scare her or just make her nervous. On February 12th, Padilla was not wanting to eat lunch, and it appears that the teacher became frustrated with her and ended up putting her in her stroller in a closet that was with the classroom. So Padilla was in a stroller because of the fact that she didn't like to be restrained or anything like that, and for movement purposes. But the teacher put her into a closet that had no windows, and she was kind of like propped up against the door and the wall, and her stroller ended up tipping over, and she cracked her skull on the floor. So her mother brought this to the court, and she actually sued the school district and the Board of Education for the injuries that she sustained. And she brought it against them as that this resulted from a dangerous condition of the public building, which is a really important fact because she brought this to the court as maintenance neglect, so like the building's neglect, it was not, or it was dismissed, so it wasn't taken all the way through. But if it would have been neglect based on the teachers, then it probably would have gone through, and Padilla's family would have won against the school district. So this is something that I imagine would happen the same exact way. Things in the court are so specific and detail oriented that you do have to have very specific things that you can prove. So if something was not neglect of the maintenance of the building, but indeed was neglect of a teacher, then that would need to be necessary. I do believe that this could happen in my school district, in which something negative happens and then it's not filed correctly, so it ends up not going through or it's being dismissed. So again, I never want to see this happen to a student, but the idea that something was not correctly submitted does sound like something that would happen. Okay, Barnett versus Caldwell. In this case, Phyllis Caldwell was a teacher and she left her classroom unattended for a few minutes. She asked another teacher to listen into her class. Now, Anthony Williams and another student began horsing around in the classroom. It got so serious that the other student actually fell on Mr. Williams and cracked his collarbone and lacerated a major blood vessel. 911 was called and he was taken and he passed away at the hospital. Now, Anthony's parents sued Caldwell for wrongful death based on neglect of supervision. And this case, it went through, but Caldwell won the case because in the district's master agreement, supervision is not defined as to what needs to be watched and for how long and how diligently. So because she was only out of the room for a few minutes and she had another teacher listening in, she actually won the case, you could say, because so specifically and detail oriented, again, supervision was not clarified. Now, in my school district, sorry, I meant to go back. In my school district, supervision is also not clarified. There's a certain amount of hours that we have for supervision, and that goes into detail in our master agreement about how many hours outside of our classroom we're allowed to spend supervising, whether that means duty before or after school or club or something like that. So I think that this would happen very similarly in my school district as well, because supervision is not defined. And again, detail-oriented things like this can cause a court case to completely change. And here are my resources, and thank you for watching.